Salutations, respected viewers. This is George from Ireland. I'm continuing my series about English law, particularly looking at EU law. But this necessitates looking a little bit at the history of the EU, and I did much of that last time. Now got to the stage in my narrative where the United Kingdom actually acceded to the European Union. So in 1972, the Prime Minister, Edward Heath, he introduced the European Communities Bill to Parliament. Now, the Conservative leadership was in favour of it. Quite a few Conservative backbenchers rebelled against. The Labour front bench was against it. However, there were quite a few Labour MPs who voted for it. It was odd, since the Labour leader at the time, Harold Wilson, had attempted to bring the United Kingdom into the into the EEC several years earlier, when he'd been Prime Minister. However, in 1972, Wilson said that Labour was against joining the EEC on the current terms. The terms offered were insufficient. Anyway, the bill was passed and became an act. 1st of January 1973, the United Kingdom joined. The Tory party lost office the next year. So Harold Wilson was back in as Prime Minister of a Labour government. There was a lot of discontent in the Labour Party about joining the EEC. Labour was not so Europhile back then. It was a highly contentious topic and very divisive of both major parties. The Liberals were pretty much all in favour of the EEC though, but they were a tiny party. So many socialists regarded the EEC as being a capitalist club and preventing them from implementing full-blooded socialist policies. Some people disliked the EEC for nationalist reasons, including Labour politicians. Some people thought that the Commonwealth mattered more, particularly our kith and kin in the dominions of Australia, New Zealand and Canada. So the United Kingdom had sweetheart trade deals with these countries, but those had to come to an end as a result of accession to the EEC. And Australia and New Zealand felt cut adrift when these preferential agreements came to an end. So Wilson then renegotiated the terms of membership of the EEC, making a realistic threat that he would withdraw from the EEC if he wasn't given real concessions. He only got minor concessions. Anyway, so he decided he better resolve the situation once and for all, and he went for a bold gambit. This was such a divisive issue that he suspended collective cabinet responsibility on this issue and held a referendum in 1975, that June. So cabinet ministers were entitled to campaign for or against the EEC. So the referendum was post factum. Now that the United Kingdom is in the EEC, should the UK remain or withdraw? And the referendum was worded in a way which slanted it towards the status quo, saying the government has renegotiated the terms of membership, as in hint, therefore it's good, it's better. And should we stay within the European Economic Community, brackets, common market, because people usually call it the common market. So cabinet ministers were free to campaign on either side of the issue. Likewise, they were sharing platforms with Conservatives, who were Eurosceptics in some cases. The Reverend Ian Paisley of the Democratic Unionist Party, he was against. He's a politician from Northern Ireland. The SNP was mostly against, and the Scottish National Party was just becoming a significant party at the time. So that was that. Anyway, it was an audacious move, and the vote came through. To begin with, it looked like 2/3 of people were going to vote against, but there was a huge shift in public opinion, and 2/3 of people voted for remaining in the EEC. So the result wasn't legally binding, but it was expected that Parliament would abide by that. And that was it, the issue was settled. It appeared to have killed the issue for all time. And then party unity could be healed, saying, even if you were on the losing side, well, I accept the will of the people, that's it. We don't need to squabble about it anymore. So Eurosceptics largely stopped carping for the next decade or so. Then there was gradually more and more integration, and the EEC turned itself into the European community, which finally into the European Union. The Treaty of Maastricht was signed in the Netherlands in 1992. And by the way, more EU member states joined. Spain and Portugal joined in 1985, if memory serves. So 1993, the Treaty of Maastricht actually took effect, and the European Union was created. There had been a referendum on that in the Republic of Ireland, or plebiscite to be more accurate, as in it was legally binding. In Denmark, people initially voted no, then they were made to vote again. Second time they voted yes. Countries like Norway and Iceland refused to join. They felt it would limit their independence too much. It would be on bad terms. It would damage their fish stock. They were correct on that one. Anyway, so enough about the history of it. Let's look at some of the institutions of the European Union. There's the European Court of Justice. It's the Supreme Court of the EU. So the Court of Justice of the European Union, to give it its proper title. But anyway, ECJ for short. It sits at Luxembourg. This is not to be mixed up with the European Court of Human Rights, which is not an EU organ, and that is based in Strasbourg. And that's very confusing because the European Parliament also meets in Strasbourg half the time. And the European Court of Human Rights administers the European Convention on Human Rights. And both the court and the convention are known by the abbreviation ECHR. So the European Convention on Human Rights has been domesticated by all member states since the year 2000. There are 20 other countries which are signatories to the ECHR. So every country which is a signatory thereof has a judge in the European Court of Human Rights, but these judges will not be sitting if the government of their country is involved in the case. They have to recuse themselves. People often use the expression European Court without making it clear whether they're talking about the ECJ or the ECHR. So it's a very common misconception. The Human Rights Act of 1998 put the ECHR into domestic British law. So public authorities are not allowed to act incompatibly with the ECHR. Now, this is where it gets complex. They might act in a way which is not compatible, but that might be permissible so long as it's not incompatible. Tricky. So there's a scintilla difference between if it's incompatible, that's not allowed, but if it's not compatible, that might be allowed. There's a little bit of leeway in between the two. So prior to this, if people wanted to assert their rights under the ECHR, they had to exhaust all domestic remedies before a court would refer the case to the ECHR. The Human Rights Act, has domesticated all this. It might be quicker, cheaper and simpler to assert one's ECHR entitlements in the domestic courts. That's to say the courts of one's member state. So the European Court of Justice is not bound by precedent, no stare decisis. And some will say, well, this leads to terrible confusion and inconsistency. Roman law is not so big on precedent. However, the European Court of Justice says it does follow the legal reasoning of the ECHR. They have overlapping responsibilities, and the judges regularly meet and have a cordial relationship. They're not rivals in any wise. So the two courts correspond with each other, and the ECJ says it regards the ECHR's rulings as part of its legal heritage. There's the European Parliament, which is elected by the member states, and obviously the states with the smallest populations, such as Malta, have the fewest MEPs. And the largest ones, such as France, the United Kingdom and Germany, have the most. However, it is not strictly proportional. So the largest member states, yes, they have the most MEPs, but it's not commensurate with the size of the population. And Malta is hugely overrepresented, about 12 times overrepresented per capita. They're multi-member constituencies, so it's not a first past the post system. It used to be in some countries like the UK till the 90s. So it allows more representation for minor parties. Now, the way it's digressively proportional is unfair, many would contend, despite the fact that the European Union is supposed to be all about democracy. Well, it's not giving power to the people, it's giving power to the very minor member states. The argument is, otherwise the minor states would get overlooked. Well, they would not get overlooked. They would have their views taken into account in proportion to the size of their population. So looking at the Council of the European Union, there are 28 member states of the EU at the moment. The Council would consist of ministers for the portfolio of the issue under discussion. For instance, if it was agriculture, 28 agriculture ministers would be there. If it was transport, it would be 28 transport ministers. If it was health, it would be 28 health ministers, and so on. It used to be called the Council of Ministers, which made the situation clearer. Now it's simply called the Council. If you think that's confusing, well, it is. This is not to be confused with the European Council. The European Council is a separate body, and it consists of the prime ministers of all 28 member states. Because of France's unusual constitution, the French prime minister and the French president have to go along. So the European Council meets every 6 months, and it discusses major policy decisions. There's a rotating presidency of the European Council, and so it goes from one member state to the other every 6 months. Now there are 28 member states. Your country's not going to get it too often. Initially, there were only 6 member states, so you used to get it every 3 years. There's another thing called the Council of Europe, which is not a European Union body. Again, these names are so similar that a lot of people are flummoxed by this. The Council of Europe includes countries that are in the EU and a lot of countries which are not in the EU. And the Council of Europe and the European Council are not the same thing. It was the Council of Europe was the organization which drew up the European Court of Human Rights, and for instance, it includes Russia. Right, coming on to the European Commission. This is a crucial EU institution. The European Commissioner has one commissioner for each member state, but he or she is nominated by his or her government, and they all have an area of responsibility like agriculture, external action, as in the Foreign Service, defence, security, education, culture, whatever it is. However, the commissioners are not there to represent the member state. They're to do the best for the whole of the European Union and not think about what's going to advantage their member state. They must be neutral in that sense. So that's that. There's a president of the European Commission in addition to this. So the president of the European Commission, he is like the executive of the cabinet, and the European Commission is a bit like the cabinet of the EU. There's no president of the EU as such. They talked about creating one. There's president of the European Commission. So the president of the European Commission, well, he gets the nominations from the member states. He puts them to the European Parliament, the list of 28. The European Parliament can accept or reject the entire list. They can't cherry pick it. And famous is a situation about 10 years ago when the European Parliament disliked the views of one Italian nominee, his views on homosexuality, so they rejected the entire list. I mean, that name was taken off, somebody replaced, and then put to them again, and then they did accept it. So how is EU law made? Well, the various EU institutions can make law. The European Commission can propose laws. Only they can propose laws. Admittedly, they offer informal discussions with other EU institutions about proposing these laws. There's co-decision. The European Parliament and the Council decide on laws. They meet separately, though. They debate laws, they vote on them. The the Council and the European Parliament must both vote for something for it to become law. They can insert amendments, it can go back and forth between them. So there are lots of informal meetings to try and hammer these things out. The treaties can also make laws. Remember the Treaty of Rome, 1957, that made laws. And there have been lots of treaties. Every few years there's a new treaty which replaces the previous ones, often includes the text of the previous ones. So there are regulations which the EU issues, and that immediately applies to the whole of the European Union. And there are directives. So these are for member states to transpose the directive into their national law by a certain deadline or pay a very heavy fine, and they've always done it. So member states must meet the requirements of the directive. They may go further than that if they wish, but they have to meet the minimum. So people in the UK often complain about the ludicrous EU legislation on bent bananas, and that is no myth, that one, how pettifogging and bloody-minded it is. Now, often it's parliamentary draftsmen going too far. Yes, it's sometimes the United Kingdom going further than it's actually obliged to do by the said directive. Decisions, the EU can issue these, and they are to whomsoever they are addressed. So they're often to certain companies or a sector of the economy, things like that. Courts can make decisions as well, and in a sense they can make law too. So some EU laws are directly applicable and others are indirectly applicable. Van Gent en Loos is another one, but we'll come on to that in more detail. Factor 10, which I mentioned previously, when the Parliament's EU Merchant Shipping Act had to be got rid of. All right, so I'll leave it there for the moment.